My name is Linda Watson, and this is the story of one man, one weed killer, and a Supreme Court ruling that just changed the rules for every American consumer. Let's start at the beginning. John Durnell is a farmer from Missouri. For approximately 20 years, he used a product called Roundup on his property. Roundup is a weed killer, one of the most widely used herbicides in the history of American agriculture. Nearly 300 million pounds of it are sprayed across this country every single year. John Durnell used it the way millions of Americans use it, the way the label said it was safe to use. Then he was diagnosed with non-Hodgkin's lymphoma. That is a cancer of the lymphatic system, and John Durnell believed that Roundup caused it. In 2019, he filed a lawsuit in Missouri State Court. He argued one thing, that Monsanto, the company that makes Roundup, had failed to warn him, that the label on that product should have told him there was a risk. A jury agreed. They awarded John Durnell more than $1 million. Monsanto appealed, and last Thursday, June 25, 2026, the Supreme Court of the United States reversed that verdict, 7-2. John Durnell walks away with nothing. And the question I want to answer today is why, and more importantly, what does this mean for you? To understand this ruling, you need to understand one law. It's called FIFRA, the Federal Insecticide, Fungicide, and Rodenticide Act. It's the federal law that gives the EPA, the Environmental Protection Agency, the authority to regulate pesticides, including what goes on their labels. Here's the critical part. Under FIFRA, a pesticide manufacturer must use the label that the EPA approves, not a different label, not a better label, not a more cautious label, the EPA-approved label. And FIFRA has a preemption clause, which means states cannot impose labeling requirements that are different from or in addition to what federal law requires. This is the legal architecture that Monsanto's lawyers walked into that courtroom with, and it worked. Justice Brett Kavanaugh wrote the majority opinion. He said, the EPA has repeatedly evaluated glyphosate, which is the active ingredient in Roundup, and has repeatedly concluded that glyphosate is not likely to cause cancer. Therefore, the EPA has not required a cancer warning on Roundup's label. Therefore, as a matter of federal law, Monsanto must use a label without a cancer warning, and therefore, a Missouri state court cannot require Monsanto to add one. That is the ruling. 7 justices agreed. Thomas concurred separately. 2 justices dissented. Let me tell you about that dissent, because I think it matters. Justice Ketanji Brown Jackson wrote the dissent. She was joined by Justice Neil Gorsuch. Now, I want you to notice something. Jackson is considered one of the most liberal justices on the court. Gorsuch is considered one of the most conservative. They agreed, together, in opposition to this ruling. That tells you something. Justice Jackson wrote, and I want you to hear this clearly, that the majority's ruling is based on a labeling requirement that does not exist. She said the majority misunderstands FIFRA's requirements, misinterprets the scope of FIFRA's preemption, and ultimately leaves John Durnell without a remedy for the significant harms he has suffered. She argued that FIFRA limits states' authority over pesticide labels, but does not eliminate it entirely. That states retain the power to impose requirements that are equivalent to what FIFRA itself requires, and that a cancer warning, if supported by evidence, is exactly that kind of equivalent requirement. The majority disagreed, and the majority wins. Now I need to tell you about the science, because this is where it gets complicated, and I want to be honest with you about that complexity. The EPA, which is the federal agency at the center of this ruling, has evaluated glyphosate multiple times since it was first registered in 1974. Every time, the EPA has concluded that glyphosate is not likely to cause cancer in humans. That conclusion is shared by many regulatory bodies around the world. The European Food Safety Authority, the Canadian Pest Management Regulatory Agency, the German Federal Institute for Risk Assessment, the joint FAO and WHO meeting on pesticide residues. These are serious scientific institutions, and their conclusion is consistent. The labeled uses of glyphosate show no evidence of human carcinogenicity. That is one side of this. In 2015, the International Agency for Research on Cancer, part of the World Health Organization, published a different assessment. They classified glyphosate as probably carcinogenic to humans. That classification is Group 2A, the same category as red meat, the same category as working as a hairdresser, the same category as shift work. Group 2A does not mean this definitely causes cancer. It means there is limited evidence in humans and sufficient evidence in animals that warrants caution. That 2015 IARC report is what launched tens of thousands of lawsuits. It is also a report that virtually every other major regulatory body in the world has reviewed and disagreed with. So here is where we actually stand, scientifically, when it comes to glyphosate and cancer. There is no settled consensus the way there is with cigarettes. There is a regulatory consensus, which says the product is likely safe as labeled. And there is a different scientific classification from one credible international agency that says we should probably be more cautious. Two conclusions from credible sources about the same chemical. And after this ruling, only one of those conclusions can be raised in an American courtroom, the one the EPA agrees with. Here's what this ruling actually changes. Before last Thursday, if you believed a pesticide had harmed you, you could go to your state court. You could argue that the company failed to warn you. You could put your case before a jury of your neighbors. That pathway, for glyphosate and Roundup specifically, is now closed. The Supreme Court's ruling is expected to result in the dismissal of current warning-based claims and to foreclose future claims based on state failure to warn theories. Prior to this ruling, Bayer had already spent at least $10 billion on settlements and jury awards from approximately 100,000 cases. 100,000 Americans who sued and either won settlements or received jury awards. That era is over. Now let me be precise about one thing. This ruling is specifically about failure to warn claims under FIFRA. It does not eliminate all legal pathways. There may be other legal theories that courts will now evaluate. There are also ongoing legislative efforts. The plaintiff's attorney in this case, Ashley Keller, noted that Congress has been debating a separate provision in the Farm Bill discussions. And the EPA is currently in the middle of a new evaluation of glyphosate, ordered by a federal court after a previous assessment was found to contain errors and inconsistencies. That evaluation is ongoing. If the EPA changes its conclusion, the legal landscape changes with it. But as of today, the door that 100,000 Americans walk through to seek justice is closed. I want to step back for a moment, because there's a bigger question here. And it's the question I put in the title of this video. Who decides what is true? The legal concept at the heart of this case is called federal preemption, and it is not new. What is significant here is the context in which it is being applied. The legal concept at the heart of this case is called federal preemption, and it is not new. What is significant here is the context in which it is being applied. A federal agency, the EPA, made a determination about a product's safety. That determination, made by scientists and regulators, now has the legal effect of preventing American citizens from asking state juries to evaluate whether that determination was complete, whether it considered everything, whether the company that made the product did anything beyond what the label required. Justice Jackson called this both remarkable and regrettable. And she raised a question that I think deserves to be heard. What happens when a federal agency's determination is later found to be incomplete? What remedy does an ordinary American have? The majority's answer, in essence, is that you can petition the EPA. You can ask the agency to reconsider. You can seek judicial review of the agency's decision. But you cannot go to a state court. You cannot put your case before a jury. You cannot ask 12 of your fellow citizens to evaluate what happened to you. That is what changed on June 25th, 2026. Now I want to tell you something important about this case, about the people behind it. Before the Supreme Court ruled, Bayer, which now owns Monsanto, had already announced a proposed nationwide class settlement designed to resolve current and future Roundup claims alleging non-Hodgkin's lymphoma injuries. That settlement received preliminary approval earlier this year. Bayer described the Supreme Court strategy and the settlement strategy as, and I'm being careful with their exact framing here, independently necessary and mutually reinforcing elements of the company's containment strategy. Containment. That is the word they used. The same week that tens of thousands of Americans were waiting to learn whether their cases would proceed, the company was publicly describing its legal strategy as containment. I'm not editorializing. I'm just showing you the document. And there's one more thing I found. During the years of Roundup litigation, evidence surfaced of what critics described as corporate misconduct and undue influence. An often cited glyphosate study was retracted earlier this year, after evidence emerged suggesting the results may have been influenced by parties with a financial interest in the outcome. I want to be precise. The retraction does not prove wrongdoing. It does raise questions, and those questions were being answered in part through the litigation process, through discovery, through depositions, through juries reviewing evidence. That process, at least for failure to warn claims, is now substantially curtailed. So what do you do with all of this? Here is what I can tell you practically. If you or someone you love has been diagnosed with non-Hodgkin's lymphoma and has a history of glyphosate exposure, call an attorney this week, not next month, this week. Cases that were filed before this ruling may still have viable pathways under different legal theories. The window is not fully closed for everyone, but it is narrowing. An attorney who specializes in toxic tort cases can evaluate your specific situation and tell you where things stand. Most of them offer free consultations. If you use Roundup or any glyphosate-based product in your yard or garden, this ruling does not mean the product is proven safe. It means the legal mechanism that previously pressured manufacturers to add warnings is no longer available at the state level. Your personal risk assessment should not be determined by a court ruling. Talk to your doctor. Understand what the science actually says, all of it. But Congress can act. The question is whether enough Americans know that they can ask it to. Make an informed decision. And if you believe the law should change, Congress still has the authority to amend FIFRA. The plaintiff's legal team made that point explicitly in their arguments before the court. Until Congress acts, state juries cannot evaluate these cases. A jury of his neighbors heard the evidence and decided he deserved more than $1 million. The Supreme Court, in a 7-2 ruling said that jury was wrong. Not because John Durnell didn't get sick. Not because his cancer wasn't real, but because the federal government had already decided what the label should say. And in our legal system, that decision belongs to the EPA, not to a state jury, not to John Durnell, not to you. I'm not telling you that's wrong. I'm telling you that's what happened. And I'm telling you because you deserve to know who is making decisions that affect your life, even when no one else is telling you. That is why I do this. Know your rights. Share this with someone who needs it. I'm Linda Watson, and I'll see you in the next one.